Good evening. It's Friday night. It's the face-off. A friend of mine, professor, former minister, if I add the other title then you would know who, I don't want that, says he doesn't quite like the name. The name suggests battle, it suggests a fight. And I said no, it isn't a fight, but it is the Friday face-off. Peter Kivazo. With me from across the table I have Charles Romshana.
The Almighty God is great.
Richard Waguma and Charles share one trait. Both of their roofs are opening up. Welcome, Richard.
It's good to lose somebody here.
Okay. We pay for that, by the way, some of us. So you, I don't know, you get it naturally. Well, we are joined by two lawyers. First on my immediate left is Edgar Tavaro.
Good evening, viewers.
I thought you were going to follow the order. Why are you skipping?
And in the center is the Mulodi.
Good evening, viewers and the panelists here.
Yes, Omlodi Elias Lukwago. I know that on the Facebook page I got like 16 requests for us to ask him into the show, and he's been courteous enough to say, okay, I'll grace the show.
I don't know why you have sandwiched me in these brains here.
Well, you have been man-witched.
Right, viewers, and of course the issue of discussion is what next? Omlodi, the judgment of the Supreme Court, depending on who you're listening to, I didn't have the privilege of coming to the Supreme Court, but we were kept updated by the minute. And my reading was that, yes, it is all over. I've learned to read the judges, and I'm glad I wasn't disappointed in my...
Read the judges or the judgments?
No, read the judges. Mark my words.
Okay.
When they start out, you know where they are going to end. And indeed they did. You've been thrown back to the Court of Appeal. And you've still stayed in abeyance. You are neither the mayor and nor are you not. Then what, politically? Is it time to let that loop go and you go the political angle and go into an election? Do you want to do battle, and until when? Legal battle.
One thing I should clarify right from the outset. The verdict of Justice Lydia Mugambe has never been set aside. And it was very clear that the impeachment, the purported impeachment process from the word go was a nullity. And indeed, there are people who were condemned. And up to now, they have not been discharged as contemners. Franka Tumwebaze, Badiru Chigundu, Attorney General Nyombi, and the others. For purporting to say that actually there is a vacancy and to go ahead to organize a by-election. You would also be risking the same if you maintain that position. I had you casting doubt
on whether you are or you are not.
Well, yes.
Well, the Kavuma decision said you may be, but you are in abeyance now.
You know, the strange thing about Kavuma's decision, it wasn't a decision, no, the injunction he gave. Because from Justice Lydia Mugambe, we got an injunction against these people who were restraining me from accessing my office and who were going ahead with the by-election because there was no vacancy. Kavuma comes up with an injunctive order. The irony is, there was already an injunctive order of Justice Lydia Mugambe. Then Kavuma also comes up with his own injunctive order.
You're speaking yes, Gujarati now.
Saying, yes, you are still the Lord Mayor, but you should not execute the functions of the Lord Mayor, whatever it means. And that is the reason we went to the Supreme Court. That's one thing I wanted to clarify. The other aspect, which is being misinterpreted within the public domain, it's as if this was going to be the final verdict. Either way it would go. Even if I had won 100%, I was obliged to go back to the Court of Appeal. Because the Attorney General was not satisfied with the decision of Lydia Mugambe. That nullified the purported impeachment. And the appeal, he filed an appeal in the Court of Appeal. So that actually it was a notice of appeal. And then he put the main application for a temporary injunction as well as a stay of execution. And he got an interim order which Kavuma issued under very mysterious circumstances.
Mysterious.
Oh yes, I maintain my position. Yes, I'm sorry to say that. With the due respect, of course. Very mysterious. You know the circumstances. Locked himself in the boardroom.
Expert here.
Not expert.
It was inter-party. Then it
If
can be
it-
mysterious, Mr. Lord Mayor.
Yes. You know, it was strange sitting in a boardroom.
Yeah, it may be
you
strange, but not mysterious, Mr. Lord Mayor. The greatest respect.
Let the Lord Mayor finish.
Anyway, whatever the circumstances, the order was issued and we were dissatisfied with it. So we were duty bound to go back to the Court of Appeal. One, to handle the main application, and two, the main appeal by the Attorney General. So I don't see any horror about that. The third aspect, if I would explain, from this very ruling that was given yesterday, the issue of a reference to a panel of 3 judges. I've heard even seasoned lawyers arguing that, look, that was the most logical thing to do. No. They have not taken time off to study the law. The law is very, very clear on this. A decision of a court of appeal can be challenged in the Supreme Court. Whether it is a single judge or a full bench, you have a right to. What are the circumstances? If you looked at the Judicature Act, if a decision of the Court of Appeal, even if it's a decision of even if it emanates from
A singular judge.
yes, a single justice, as long as it has the effect of either varying, rescinding, or setting aside the order of the High Court, you have a right to challenge it in the Court of Appeal. And this is exactly what we did. One of the grounds of appeal, in fact, succeeded, that there was no quorum in the Court of Appeal to entertain an application for of that nature. That Justice Kavuma could not sit alone to issue an injunction, because an injunction must be issued by a panel of 3. So one of the grounds of appeal was
That.
there was no quorum. The Court of Appeal was not fully constituted, was not duly constituted. Well, so you cannot have a reference to a panel of 3 judges where there are irregularities. That's not a matter you do take there.
Omrodi,
Yeah.
the political bit of this, that is the legal bit. What do you do next? Do you go back to court? Do you go political? Do you go to the people and say, okay, to hell with the legal process, I go for an election straight? Or do you still hustle it out in the domains where the literature I can barely comprehend?
There is also that argument within the public domain.
Very briefly.
Very briefly. Yeah, actually, last week I was at a forum with PhD students organized by Professor Mahmudan. His view was that this is a political battle. You had better fight it politically. But look here, you are losing sight of the fact that you have to do everything within the paradigm. Yes, within the confines of the law.
Yeah, sure.
As we talk today, there is no vacancy. There cannot be a by-election. So how do you now organize for a by-election when there is no vacancy? The law says there is no vacancy. And there
But
cannot-
there is neither a mayor.
who says that?
There's a Lord Mayor.
There is a Lord Mayor who has been stripped of his duties. And that's the thing, whose office has been locked, whose instruments of power have been confiscated, and that is a legal battle. So now, let me ask you who is advocating for that approach.
No, I'm asking.
Yes. The challenge now I'm facing is how to get back the instruments of power from the person who has confiscated them. Naturally, of course, it is the president who has the tools, the instruments of power. So how do I get them politically? I have to first deal with him legally.
Edgar,
Yes, please.
you are the only other lawyer on the panel. And
Fortunately.
luckily. And I've seen you taking a lot of notes. Before I go to Charles and Richard, give me your feel. You've listened to the Mrodi. You've had opportunity possibly to interact with the circumstances before.
I've had opportunity to discuss this subject before, and in fact have written on it. I think
Where have you published? The journal or Facebook?
Mr. Robjana, it matters not where I've published it, but I've reduced my thoughts into writing and shared widely in a newspaper and social media. I think what we have before us, and really what I want to bring to the fore for everybody to note, is that we are faced with a situation where we have to debate either the law of politics or the politics of the law. Because you're putting it to the Lord Mayor that now that you're required to go back to the Court of Appeal, what next? Do you go to the electorate or do you continue legally? And Kwanza, it's my most considered opinion that political disputes should not be brought to the courts. Politicians should be able to sit down and dialogue. But where they elect to come before the courts, then they must abide by the processes that come out of the courts, whether they're in your favor or not. So the use of the words mysterious, with the greatest respect, frankly, I don't think this is the language that we ought to be using. Eh? And I'll give you a background to this. I'll give you a background to this. When the Constitution had just been enacted in 1995, we do remember, Mr. Lord Mayor, there was wide debate on whether a court can reverse a legislative action of Parliament. Now, it was previously thought that Parliament was what? Was supreme. And you remember that debate? There were these judges. I don't want to mention names. Some of them are happily into their retirement and they're very respected citizens. But there was that philosophical foundation that was challenged. And it took a while before the courts started reversing decisions of Parliament. So now I'd like to come into the scenario that we have today. Let me start with, you remember when Olaro Tuno had been, was arraigned before the courts to be prosecuted, I think, for, was it defamation? Criminal defamation of the name of the president of the Republic of Uganda. And the judge, unfortunately, is of good memory, is now deceased. He entertained the application as a single judge, as a single justice of the Court of Appeal, or rather the Constitutional Court. Mind you, the quorum of the Constitutional Court is what? 5 judges. Now here was a single justice sitting in the decision of that and awarding an injunctive relief, an intellectual relief, staying his what? His prosecution in the magistrate's court. Mind you, the same judge in the previous application had rejected, saying that a single justice cannot entertain what?
Can I give you information? At one point, yes,
please.
I've been a beneficiary of that.
Yes, and I'm saying, no, what I'm saying, really, there's nothing mysterious about these things.
No.
This is what I want to put to the public out there, that there are these jurisprudential questions that keep arising. Now that the Supreme Court has set the record right, or has set the precedent, then we can all follow.
Yes, you are giving information. Yes. Very briefly, so I bring in the political perspective of this.
I'll also come to the political perspective.
There would be no problem, a single judge sitting to give some reprieve, interlocutory relief.
Yes, please.
But the precedent set, even in this very ruling,
yes, please,
when it is an injunctive order, a single judge has no, actually
doesn't have
jurisdiction.
Yes.
This is where I have a problem. If it were any other relief, say staying the execution, no, that one actually also has no powers. If it was some other relief which which was within the parameters of the powers of the single judge, there wouldn't be any problem.
So thank you very much, and this is what I'm trying to
But in this, that is one aspect. But here, he exceeded his jurisdiction. 2, also the right to be heard. My lawyers came, they knocked, the door was locked.
But you had been a beneficiary of another judgment that came ex parte, the injunction against the meeting.
No, it was inter partes.
Well, the Attorney
The one
General
at
still,
8:30.
yes, the Attorney General still insists
The
it
one at
was given
8:30.
ex parte.
No, you were
No,
there.
that one, it was an interim order issued by a registrar
Pending hearing before
pending
the judge.
hearing before the
Minutes
judge.
before the judge.
It was
in such a nature, you can be
that
awarded.
one. There is no
It can be
problem.
awarded. It can be awarded. That's true.
But here there is already a verdict of court at appellate level.
Okay, I'll
And
hold the
then you
lawyers.
sit and issue an injunction as a single judge. That's a different
But
matter.
let me.
And yes, very briefly,
frankly,
Edgar.
And really, I don't want to politicize that bit because previously there were even those who there was a school of thought that a registrar or a person sitting as a registrar in the Court of Appeal could award such an injunctive relief. Remember?
Yes.
And really, the Lord Mayor Lukwago knows it. He has been battling in courts ever since I got to meet him. As no, he knows.
Yes, Edgar, very briefly. I need this closed so I bring in the other guys.
Yes, please.
So your political face on this, because you've taken us through the legal
Yes, the
angles
political
of it.
face is that, and frankly, there was an election. Lukwago beat NRM hands down. With what? It was a landslide, 60.1%.
64
Point whatever.
0.1%.
If they need to oust Mr. Lukwago, they should wait for 2016. For now, he's the Lord Mayor. And as to how we get to that, we shall get into that discussion. But for now,
I'll pause you there.
Yes, please.
I'll pause you there. Viewers, I'm taking a very short break. And I return with Richard Baguma and Charles Romshana. I was actually going to call him Charles Biaruhanga. He isn't. Don't go away.
He's actually a Biaruhanga in nature.